You've probably heard that a living trust avoids probate, keeps things private, and saves taxes. Well, 2 of those are true, 1 is not. If you've got a house, investments, or a business, this is for you. You're going to leave with a simple checklist that you can finish this week and a way to keep your family out of court, out of the news, out of all sorts of fights, right? So here's the plan. First, I'm going to explain in plain English what a revocable trust does. A living trust is what a revocable trust is, and what it doesn't do. Then I'll give you a quick win. I'm going to give you a 20-minute funding checklist that most people skip. After that, we'll cover when a will is enough, when a trust is smarter, and how married couples can lock in bigger estate tax protections using portability the right way. We'll close with mistakes that cost families time, money, and relationships, and how to avoid every single one. And as a bonus, I'm going to give you an electronic version of the Anderson emergency binder. I got a physical one right here, but you have to share this video with somebody you care about. So I'm going to give you the e-version of this binder. And don't worry, we use the honor system. I'm dropping the link to the free emergency binder in the show notes. You can see why this matters as we go on, because this is so important. This is the thing people leave out all the time, which is organizing their estate, making sure people know what your wishes are during your lifetime before we even get to living trusts, wills, power of attorneys, and things like that. This is very powerful. I'll go over why in a little bit. So let's go over what a living trust actually does. I'm not going to use any jargon here. A revocable living trust is a legal bucket. It's just you have control of this bucket while you're alive. It works from the time you sign it to centuries after you're gone if you want it to. Unlike a will, which only works at death. In the trust, you are the grantor, which is known as the giver or the settlor, the person who created and funded the trust. You're also the trustee, the one who is in control of those assets, and you're the beneficiary during your lifetime. If it's a joint, then you both are. If you are incapacitated or you pass, the trust kicks in and has successors named for the successor trustee and successor beneficiaries if you pass away. It's as simple as that. It's kind of like a little list. So during your lifetime, you're the trustee now. You can change the trust at any time, and everything in the bucket follows your rules when you're incapacitated or when you pass. You get to say who gets to take things out of the bucket, when it gets to come out, when things go out. If you'd rather, think of this almost like carry-on luggage. If you don't want to think of a bucket, think of it as carry-on luggage that you get to access anytime you want when you're alive. If you can't haul it anymore because it's too much for you, you're incapacitated, you need somebody else to haul it around, you've got a successor trustee, and then when you pass, it says who can access it. So here's the big wins. Your family avoids probate court. You get privacy because of that. In other words, your stuff remains outside of the courts. And your successor trustee can step in fast to pay bills, sell assets, and follow your instructions. All of this without a judge. During your lifetime, if you're incapacitated, you have somebody there to help you with the power of attorney and also the trust. And after you pass, you have it. So whenever I hear someone say, what's the difference between a will and a living trust, I immediately think of something, here's an analogy, a car and a bicycle. The will is a bicycle. You're exposed. It only works well under limited circumstances. And if you have stuff, it is very limited in its effectiveness. Think about trying to haul groceries on your bicycle. Plus, if there's an accident or a dispute on that bicycle, you have limited protection. That's the will. A living trust, on the other hand, is like an SUV. It does really well on long trips. It provides a ton of protection when you want it. It's private. Think of an SUV with blacked out windows. And it does really well if there's disputes, if your family fights. It's a very strong vehicle. Not only that, but your living trust works during your lifetime. They all have documents. All living trusts have documents for medical events, financial events, and end-of-life events versus a will, which only works when you die. It is not a fair comparison. The living trust is far superior in almost all ways. But here's the part most people miss. For taxes, a basic revocable trust doesn't cut your income tax. and it doesn't by itself reduce estate taxes. It's not an asset protection tool, it's a nothing during your lifetime. The tax magic in revocable trusts is about organizing, not escaping. In a nutshell, most people know a will requires this legal process called probate, while a living trust can avoid it. I say can, because you have to fund it. In other words, you have to put your stuff in the bucket or in your carry-on luggage, whatever you want to call it. It has to be in there. So why bother? Because probate is slow, public, expensive. It can be a real, and you might have to do it in multiple states. A funded trust turns a potential court file into a private checklist your trustee executes quickly and quietly. I'm handling a probate right now for a really small estate for a friend of mine who passed away. It's going to be a year and at least 10 grand in attorney's fees. Not mine either, I'm not paying, I'm just the executor. And this was for a small estate that is virtually insolvent. Since I said funded living trust, let me help out all the people out there who have living trusts already or who are thinking of putting one together for themselves. You ready? Most people sign a big, beautiful trust and then forget to put anything in it. So you got this big bucket, but it's not full. Or I got this big thing of luggage, but I haven't put anything in it. If your trust isn't funded, you don't really have a great plan. So here's a funding checklist, and you can check these in about 20 minutes or less. Ready? I'm just going to go over types of assets and what you need to do. Number one, real estate. Deed title from your name to the trust, unless it's already in an entity like a residence privacy trust or an LLC, and the trust is on those. Make the living trust the owner of the LLC or a beneficiary under a privacy trust in those cases. Number two, bank or brokerage account. Ask the financial institution for their trust ownership or transfer to trust forms. Right? You got to make sure it's in the name of the trust. Number three, business interests. Your membership or your stock assignments should be signed transferring your interest, whether it's an LLC interest of a membership interest or shares in stock, into the trust. And there should be an assignment. When we do these, we oftentimes put boilerplate assignments so you can just write these things in. And make sure that it's also recorded in your operating agreement if it's an LLC or your bylaws. Just make sure it's documented that the living trust, you as trustee of your living trust, owns that asset. Number four, life insurance. Now, you might be the policy owner, so keep the policy owner as you. But the trust generally is going to be one of the beneficiaries. So you can make it a beneficiary, you can name a beneficiary, but they're getting that cash. If you want control over how the proceeds flow, you should have the living trust named as a beneficiary. Number five, retirement accounts. Generally, you keep the ownership as is. It's already a trust. Use the living trust as a contingent beneficiary in case the beneficiaries that you have listed pass away, or if you want to control how those proceeds are used. Otherwise, let's say I just leave it to a child and they get my IRA or my 401k, they're going to be able to spend it however they want. But if I want to control, hey, I'm worried about them, maybe they have, they're really bad at picking spouses, maybe they're prone to litigation, maybe they have special needs or something else, I might put it in the trust so that there's guardrails on it. Number six, personal property. Use the trust's general assignment and specific list for high value items. When I do a trust, I always put there a blanket form that transfers all of my personal assets into it, but it's always a good idea if you have high value items to list them out. So again, I tend to use a catch-all as well to make sure that my intent is clear, that all my personal assets are in there, but it's always wise to list valuable items, and if it's titled, make sure it's titled in there. Number seven, digital assets. You need to create a master inventory, password manager, seed phrases, custodians, whatever. So your trustee can actually find and manage your stuff. Crypto, domains, storefronts, accounts, all of that. Now, if you do this, and by the way, this little emergency finder, again, I'm going to give you the electronic version. It has a password sheet, and this is where a lot of people get a lot of benefit. You could list in the document itself, Here's where my crypto accounts are. But now you're worried that if somebody gets this binder, won't they have your passwords? That's why we put it in a separate folder. There it is. It's your emergency binder passwords, and you keep that separate. You keep it in a safe or with an attorney or somebody that you trust. But it's not going to be the password sitting in there with your username and access information. But you should still make sure that that is listed somewhere so that somebody can get access to it. And if you have that living trust, you could just say, hey, it's in my emergency binder. And then those two things together are super, super potent. Again, that emergency binder, go down and download it absolutely free. Share it with somebody. Run through this list that I just gave you, and you'll be ahead of 90% of the people who think they're already done. A lot of people just sign the trust and they think they're done. And that gets you a long ways there, just doing the trust. But you got to make sure it's funded. Even better, why don't you go get that emergency binder, because it has everything you need in case there's also an emergency. And we know life happens. Like, who's my doctor? What medications do I need? Yes, it's in the emergency binder. Hey, what about things like my social media accounts? I got Meta, Insta, TikTok. Keep in mind, nobody will be able to access them. The emergency binder solves that by keeping the passwords. It's numerical. It just says, like, here's my Meta, here's my username, password is line 10. They need both documents in order to figure that out, right? And it's not listed anywhere except the password doesn't even have the username or what it's for. It's just literally 10, and there's your password, and it keeps them separate. So it's a way of making sure that we can solve that issue. But somebody needs to be able to get into your accounts, and I've gone through this so many times now. If you don't have that listed, your family cannot get access, and they can't legally get access to your social media accounts afterwards, which is really unfortunate. They'd be locked out. Now, what assets do I own? Where are they? Yep, it's actually in here as well. You're listing out what your strategies are, who your advisors are. All of that is in the emergency binder. What if you're military? How does my spouse or heirs, how do they get my benefits? In here? Yes. What if I want, they need to be able to request military honors. Is that helpful? Is that in here? Yes. You can even go so far as to make sure that the proper terms for your service and how you want to be remembered, it's in here. How about who will take care of your pets? You got it. It's in there. Kids, who are their friends? Where do they go to school? Everything that you would need to be able to transfer for somebody so that they understand how to step in your shoes in case you're not able to. And this could be just incapacitation. Yep, it's in there. In fact, I think the emergency binder is probably the single most important document to help organize your estate that there is. So download it right now for free. If you want one like I was holding, like if I want the red binder and you just like a big physical red binder that you can keep at home where it's easy for your family to find, I'll put a link in there in the show notes and you can buy it. They're pretty inexpensive, but they're easy to get. But if you want the free version, just go in there and download it. It's actually really helpful. All right, now let's go back to the will and the living trust, because it's probably the most common question I get. What is the difference, right? When is a will enough? Well, when you're okay with probate and your estate is really simple. When there's nothing to fight over and you don't mind the public seeing everything that you've owned, then a will is fine. Like, there are some states where it's quick. It's still, in my personal opinion, the trust for everywhere I've lived is superior every circumstance, because there's so much that you need to address. I need to have the power of attorney so somebody could step in my shoes for health matters. I need to have the power of attorney for financial. I've had to use these because I've had family members that had Alzheimer's. You got to have that stuff before you need it, because if you need it and you don't have it, it's too late and it's already in the trust. But if you just, somebody super simple, a will is better than nothing, right? At least it says here to a judge, here's who I want to have get my stuff. And by the way, even when we do a living trust, we have a pour-over will that makes the trust the sole beneficiary of your estate, so you can probate it. You might do a really small probate if you want to close down all creditor claims and make sure that nobody can come after the estate after somebody's passed. But it's private. It just says the living trust is the beneficiary. It doesn't list out all the assets. Somebody can't go in there and see what's going on. When is a trust better? Well, when you want speed, privacy, and ongoing control after you pass. This is really important for blended families, people who have rental properties, family businesses, or beneficiaries who need guardrails. Think spendthrift issues, special needs, substance abuse issues, right? We want to make sure that we protect it. So let me repeat those. You want to trust with blended families to avoid accidentally disinheriting your kids, somebody's kids. Again, we get blended family. Mom and dad, it's the Brady Bunch, each have 3 kids. Dad passes away. Mom gets everything. It's just because there's no estate plan, she gets everything. Or underneath the estate, or maybe there's a will and it goes to mom. Mom remarries. Dad's previous, the 3 kids from first husband, disinherited. You know, she passes away and leaves it to her new husband, and she disinheriting pretty much everybody, right? It's just going to the husband, and then the husband can decide where he wants it to go, right? So we don't want to accidentally disinherit kids. I've seen it way too often. It happened even on my mom's side of the family. It sucks. A living trust avoids it by locking it down. So dad passes away, it's locked down. Here's my beneficiaries. Mom might be the beneficiary during her lifetime, and then it goes to the kids, but she can't give it away or remarry and cause you to lose it. Rental properties, unless you want to probate, in multiple states, you need to have some sort of a plan. In other words, you have to probate everywhere you own real estate, unless it's held, like if you did LLCs, you could at least only have to probate it in the state where you were residing when you passed. But a living trust could avoid it completely. It just keeps you from having to do multiple probates just by putting everything into the trust. Now, I would use LLCs and things like that for asset protection, especially if it's investment property. But the trust can avoid those issues. Now, what about family businesses? Well, I'll just tell you this. They don't survive without a structure and a plan, period. They're done. Toast. If you own things as a sole proprietor and you died, my business died. And it takes a long period of time if I'm going through courts to try to get access to a business. It's just unneeded complexity that you can avoid very simply with a simple document like a living trust. Beneficiaries who need guardrails. So think they have multiple exes, right? They have a bad picker. They keep picking the wrong spouse, and they're going to get divorced over and over again. You don't want your inheritance to get blended into that mess. If they are just a beneficiary under a trust and you have a trustee that can restrict, that's perfect. That keeps it from getting drawn into divorces. If they have lawsuits, or if they're in a high-risk profession, they're a surgeon or something, you might not want to just give it to them. You're going to want to have certain restrictions on when they get it, because they might not need it anyway. You might want it to go to future your future descendants, so your grandkids, your great-grandkids, etc. What if you have children with special needs? What if you have beneficiaries who have special needs you don't even know yet? You've passed. You want to make sure that there's provisions to protect it so that they don't lose state benefits. Again, we've seen this happen multiple times. Grandparents leave their grandchild who has special needs a gift as part of their estate, a inheritance, unknowing that the state that's been providing benefits is now going to seize that inheritance and take it from the beneficiary, simply because they've been giving these benefits and now they're going to get reimbursed because all of a sudden they have things. Or they may lose the special needs benefits they're receiving under their state because now they have other resources. Or you have children that have, or descendants that have substance abuse issues. All of these things, you need to have a trust. A will is not going to cover it. Now, let me just give you a simple rule of thumb list for all you busy investors out there. Here's a real simple one. If you own a home, rentals, or a business, do a trust. If you care about keeping your affairs private, do a trust. If you don't want all your stuff out there in a public record. If you want to control how and when your heirs receive money, do a trust. If you are okay with court, notices, and delay, a will can certainly work, but expect that there's going to be a process, and that process is oftentimes expensive. Now let's switch gears to what happened to the estate tax landscape after the One Big Beautiful Bill, this recent bill that passed, and why portability still matters. So, number one, a living trust by itself does not reduce estate taxes. It's tax neutral. But planning with your spouse does, especially with portability, which lets a surviving spouse keep any unused federal estate tax exemption from the first spouse to die. So after the One Big Beautiful Bill became law, several firms clarified that the estate and gift tax exemption does not fall, it's not reduced in 2026. Instead, it increases to $15 million in 2026 with inflation indexing thereafter. So it's going to keep getting bigger. And that shift changes the urgency, but it does not eliminate the planning. So the key points that everybody should care about if this hits you: portability election is still critical for married couples, even post the One Big Beautiful Bill. If you don't file, you can lose millions in shelter. Commentary from estate tax planners continue to stress the deceased spouse's unused exemption. It's planning value for couples, plus things like generation skipping tax exemption isn't portable. So if dynasty level protection matters to you, your plan, not just your exemption number, that really matters. So translation, use trust to control and protect, use portability to preserve exemptions. And some of you guys are saying, but I'm small. But all right, I get it. They're different tools, but use both if it gets triggered. If you have a small business, it can happen very quickly. If you have a bunch of real estate, it can happen very quickly. If you have a bunch of crypto, it can happen very quickly. In my experience, here's where families bleed money and time. And let's just call them the biggest estate planning mistakes people make. Number one, a will is good enough for me. EGATs, they find this out during their lifetime, right? COVID taught us a critical lesson about having medical power of attorneys, HIPAA releases, living wills for the end-of-life decisions, and financial power of attorneys for when somebody is incapacitated. We saw this all during COVID, and it's all part of a living trust. The people that didn't have them really suffered. People who did were able to advocate on behalf of their loved ones. People were able to advocate for them. Number two, I signed it, I'm done. That's all I need to do. If you don't fund it, your estate still is headed straight into probate. So if you're doing a living trust to avoid probate, you gotta fund it. Here's another one. I already talked about this. My trust saves me in taxes. Not by itself. Revocable trust is not a tax shelter. It's not an irrevocable trust until you pass away. It's tax neutral during your lifetime. I'll fix this later. I'll do that trust when I get older. Look, incapacity can hit first. If your trustee can't step in because accounts and property aren't titled right, bill stacks up, assets can go through a fire sale. You need to have these things done correctly. You need to have them done timely. Somebody says, I don't need portability. Maybe. But if you're married and don't elect, you can waste millions of exemptions if you like in a situation where you wish you had. Seen it way too often. When money comes, it comes quick. You want to make sure that you don't go overneath a level, or Congress changes it and lowers it again, right? So we want to use that portability. We still want to make sure that we're doing it. And this is one of those, once you need it, it's too late issues. You need to put these things in place before there's a problem. It's like insurance. You buy it before you have the car accident, right? Because if you have the car accident and you say, oh, I want to insure that, too late. All right, now let's make this real. Let's go over a few real life scenarios investors often ask about. Scenario one, the rental portfolio. Let's just use Maria. She owns a primary home, 3 rentals in different states. She signs a revocable trust but only moves the home that she lives in. And then she passes away unexpectedly. The rentals are still in her name. They have to go to probate in each state. Yes, these are probates in each state where that rental property is held. So if there's 3 rental properties, you might be doing 3 different probates. Her kids wait. They have to pay a bunch of lawyers. They fight. They get annoyed. Look, I live this in my family on my dad's side. I feel like a caricature right now, right? Where we gave up just some parcels of land because it was too expensive to probate it. It was more expensive than the land was worth. A living trust would have the successor trustee and allow you to sell these things immediately by having it titled appropriately. Let's do scenario number 2. We'll call it the blended family. Let's say it's James and Karen. Each have kids from prior marriages. Their trust sets up family trust shares, so the survivor has income for life. So the remainder passes to both sets of kids fairly, no fighting, no accidental disinheritance. If they'd relied on a will in joint ownership, or joint ownership as well, like it can be will and or, the survivor could change the beneficiaries and cut out their stepkids when the first spouse passes. A trust helps you keep those promises by becoming irrevocable. When the first spouse passes, that portion cannot be changed. The surviving spouse can't go in and change that half. Let's say that it was 50-50. They can't go in and change the half of the decedent and disinherit it, their stepkids, right? That can't happen because it becomes irrevocable. You don't do that, they certainly can. Or they could accidentally, like in the scenario in my family, get remarried and accidentally disinherit it. It might not even be something that they're thinking about. How about scenario 3? Let's just call it the business owner. So Aaron owns an S-corp that throws off pretty healthy income. With a funded trust, his successor trustee can vote those shares, keep payroll rolling, and sell on good terms if something happens to Aaron. Without it, the company would stall, it would get stuck, and we'd probably need a court order to even get access to things, and the value can vanish. And it could also happen, by the way, with incapacity. It might get frozen up, especially if there's no documentation. Who can vote these shares? So it can be very, very bad situation. Now, I want to go over the 5 costliest mistakes and how to avoid them. We've already gone over number 1, but I'm going to repeat it again. Not funding the trust. Solution, run that checklist this week that I gave you. Deeds, accounts, business interests, insurance, beneficiaries, digital assets. You gotta fund your living trust. Go back and just spend some time going over that. Number 2, forgetting beneficiary designations. The solution, coordinate your beneficiary forms with the trust plan. Make sure that you're specific who gets it and that it is clear as to who gets what, because conflicts cause messes, even in living trusts. You got to make sure that there's some teeth in the document, but that you're being very clear. Make sure you're working with a good drafter. I see people draft their own stuff, and sometimes it's clear as mud. And you're like, now I know that there's this weird legalese sometimes when we use terms like descendants and per stirpes and all these different terms. Pro rata share. I get it. That's because that words have meaning, and we're making sure that we're getting rid of any ambiguity so that a successor trustee can step in. Speaking of which, number 3 is naming the wrong successor trustee. You want to pick somebody who's organized, honest, and calm under pressure. And I would say consider having co-trustees for complex estates or a corporate trustee, somebody who works in a trust department that does this for a living. Do not just list your beneficiaries as trustees unless you're okay with them taking the estate, right? Because it might say, hey, I don't want you to distribute this until you've gone through college, you've hit 40, or whatever, right? Or it may just be health, education, maintenance, and support. Hey, you only get money when you need it. And then they say, oh, I need it. I'm the trustee and the beneficiary. I'm just going to take everything. So you got to make sure there's somebody else designated. Work with the professional. They'll give you your options, right? You call our offices if you want. We will give you your options. Many of my clients want to preserve their estate and kick off money for their descendants for decades or longer. And it's not what you think. It's not just kicking out money. Maybe it's for college funds. Maybe it's because you want them to travel. Maybe some of my clients want their kids to do mission work, things like that. Maybe you want to have low interest loans for family, right? Where I just want to be the family bank and they're going to get paid back, but they want to give everybody a start. These all require a trust. Number 4, there's no disability plan in your estate. Solution, add a good power of attorney and health directives alongside the living trust. Now, we put them in our documents. Almost everybody does the same thing, but make sure that you have your living trust, your power of attorney for health care, your HIPAA releases, your health care power of attorney for financial matters, your living will, your end of life decisions. Make sure that, and put it right in there along with your trust so that you can make sure that your trustees and your power of attorneys can act before you have to, so you don't have to go to a court. All right, number 5, there's no instructions for digital assets and crypto. And by the way, this is a huge issue. It's millions of Bitcoins are being lost. I think it's like 1 to 3 million they're estimating per year because somebody does not have access. Again, feel like a broken record. Emergency binder, make sure that how to get access to these things is in there so that your trustee can actually use it. So you want to have an inventory that your trustee can actually use. The emergency binder hits this as well and it's free. So hint, hint, go download it if you haven't already done it. Putting it all together. I'm just going to call this the 1-hour trust tune-up. And I'm going to give you a simple sprint that you can do this week. So part one, I'm just going to say it's probably going to take you 25 minutes. Inventory everything: your homes, your rentals, your business interests, your bank and brokerage accounts, your insurance, your retirement, alternative assets you have, digital assets. You already know what I'm going to say. You could use this as a template. Maybe you have financial plans or financial statements, net worth statements, whatever you've done maybe for some banks or whatever. Just go out and do it and just start listing everything. Part two, do a title and beneficiary audit. For each item, confirm whether it's titled in the trust and whether there's a beneficiary where it's listed, where there may be a co-owner or there's a successor beneficiary, and make sure that it's going to the right person. Or if you don't want it going to an individual, make sure that it's going to the trust. Part three, and this is 15 minutes. This is a successor setup. Confirm who takes over if something happens to you. Add backups. Put in their contact information, maybe their credentials in a simple break glass envelope or digital vault. Like, again, you're going to have one right here. And then here's the last part I want to go over. Just some frequently asked questions. Can I do it myself? I'm seeing this more and more online. Can you DIY a living trust? Yes, technically you can. I mean, YouTube's overloaded with how to make a trust content, right? But the risk isn't the documents, the funding, the titling, the coordination. It's the drafting. Because a cheap plan that fails costs your family real money. So these do-it-yourself videos probably are drawing traffic, but they're not really helping anybody. You want to make sure that you have a properly drafted living trust. And I'm sorry, if you haven't been doing it for years, you're going to make mistakes. Number two, will a living trust lower my taxes? For income and estate taxes, no. It's about control, privacy, and speed. Estate tax planning uses exemptions, portability, and sometimes irrevocable strategies, but they're identical whether you're using the living trust or the will. You still need to take advantage of them. The trust is going to spell it out, so it's going to give direction, but it's tax neutral. What if my kid has issues, or I'm worried about a divorce, maybe I don't like their spouse? Well, then you look at beneficiary controlled trusts and distribution rules. You can protect the gift from going to creditors and ex-spouses while still supporting your child. These are spendthrift provisions, and they're in all of our living trusts. Make sure that your documents, if you have a living trust, make sure that it has the spendthrift provisions that somebody cannot force out the asset. How about, do trust fix state property tax problems? Well, I would say like sometimes not, right? In California property, I think it was Prop 19 changed the game. Just make sure you're talking to somebody local or that has a tax expertise before you're moving title, just in case you don't want to have, but for the most part, you can move your home into a living trust without adverse consequences. Now, imagine this. You have two siblings, Alex and Jordan, right? Alex's parents had a will, not a trust. When his dad passed, the house and the brokerage account hit probate. Everything's public. The court took many months. On average, it's about 18 months for a probate. The market dipped. The family had to pay fees. They missed a window to sell assets at good price. And they had their relationships amongst them strained. That's not an ideal outcome. Jordan's in-laws used a revocable trust. The titles were updated. The successor trustee stepped in the same week that they passed, paid bills, listed a rental, transferred the portfolio in days. No court, no headlines, no family war. Now here's the thing. Same love, same assets, different paperwork, wildly different outcomes. That's the power of a funded living trust paired with smart portability planning. A revocable trust is your fast, private, no court plan, if you fund it. It doesn't automatically cut taxes. Portability and advanced planning do that. Run the 20-minute funding checklist this week that I put in earlier. When used with the emergency binder, again, this will cover you and your family from now to potentially centuries from now. This is kind of an old adage I want to leave you with. Your family legacy either starts with you or ends with you. You get to decide. Speaking of decisions, like and subscribe, share with a loved one, get your free emergency binder, share it with anybody who you think would like one. Please do that. We want to help the world make sure that they have their estates bound up so that you don't end up being a story that somebody's using as a horrible probate gone wrong. All right, guys, good luck.